Hello everyone, my name is Aaron Woodman, and I want to welcome you to my YouTube channel. In this video, we are going to talk about your right to criticize public figures and make mistakes. We will look at a Supreme Court case that deals with libel, which is a publication of a false, damaging statement in print, writing, or pictures that hurts a person's reputation. We're going to see how the standards of libel affect your free speech rights. Let's begin with the historical background. In March of 1960, student-led sit-in protests of segregated lunch counters had spread across the South. At the same time as Dr. King was supporting the student actions, he was preparing to defend himself against felony perjury charges for allegedly making false statements in connection with his Alabama state tax returns. Meanwhile, in New York, a committee to defend Martin Luther King and the struggle for freedom in the South was formed at the home of a singer and civil rights activist Henry Belafonte to raise money to provide for his legal defense. On March 29th, the committee took out a full-page advertisement in the New York Times to support the student demonstrations and condemn the actions taken against the activists and Dr. King. The ad began by paying tribute to the, quote, thousands of Southern Negro students that are engaged in widespread nonviolent demonstrations and positive affirmation of the right to live in human dignity as guaranteed by the U.S. Constitution and the Bill of Rights, unquote. It also highlighted some of the nonviolent actions taken by students, the terrorizing responses they faced in Montgomery, Alabama, and other southern cities, and how Dr. King, quote, has inspired and guided the students in their widening wave of sit-ins, unquote. The committee urgently requested donations via a mail-in coupon for, quote, this combined appeal for all three needs, the defense of Martin Luther King, to support the support for the embattled students, and the struggle for the right to vote, unquote. Reaction from state officials was fast and furious. L.B. Sullivan, a city commissioner of Montgomery, wrote to the New York Times 10 days later demanding a full retraction. Although he was not named in the ad, Sullivan claimed that it accused him of grave misconduct and improper actions as a city official. The New York Times responded to Sullivan that it was, quote, somewhat puzzled as to how you think that statements reflect on you, unquote, and that the advertisements was substantially correct. Sullivan promptly brought a libel lawsuit against the New York Times and the four black ministers from Alabama whose names were listed as endorsing the appeal, the Reverends Ralph Abernathy, Fred Shuttlesworth, S.S.C. Sr., and J.E. Lowry. He saw $500,000 in damages. The governor of Alabama, John Patterson, sued the New York Times and the ministers for libel as well, but he included Dr. King as an additional defendant. He asked for $1 million in damages. With this background information in mind, let's talk more about this lawsuit. Presiding over Sullivan's libel trial against the Times and the ministers was Judge Walter Derwin Jones. Judge Jones maintained strictly segregated courtroom seating. He had also spoken of his admiration for, quote, white man's justice, a justice born long centuries ago in England, brought over to this country by Anglo-Saxon race, unquote. Perhaps not surprisingly then, from a panel of 36 potential jurors, only 2 were black, and both were successfully challenged by Sullivan's lawyer so that an all-white jury was selected. At every libel trial, the plaintiffs had to prove 4 crucial elements. 1, the statements at issue were about the plaintiff. 2, the statements were false. 3, the statements injured the plaintiff's reputation. 4, the statements were made publicly by the defendant. To establish this, Sullivan claimed that this paragraph mentioning Montgomery police was referring to him given his supervisory role over the department. The paragraph states, quote, in Montgomery, Alabama, after students sang My Country 'Tis of Thee on the state capitol steps, Their leaders were expelled from school, and truckloads of police armed with shotguns and tear gas ringed the Alabama State College campus. When the entire student body protested to state authorities by refusing to register, their dining hall was padlocked in an attempt to starve them into submission, unquote. Sullivan also maintained that the reference to, quote, Southern violators, unquote, arresting Dr. King implicated him as well. Sullivan's lawyer, M. Ronald Nachman, called 6 witnesses who said they associated these statements with Sullivan and that if they had believed the statements, it would have damaged their opinion of him. On cross-examination, 5 of the witnesses admitted they never saw the ad until Nachman had shown it to them in preparation for trial, and none of them believed the statements. As for the issue of falsity, some minor factual errors in the paragraphs at issue were established. There was no evidence that the Alabama State College dining hall had been padlocked, and Dr. King had been arrested not 7 times, but only 4. Abernathy, Shuttlesworth, C.E., and Lowry testified that they had no knowledge of the ad until after it was published. The ad's author supported this, saying that their names had been added at the last minute without their permission, because there was no time to reach them. The jury took a little more than 2 hours to find in favor of Sullivan. The 12 white men awarded him the entire $500,000 he had asked for in damages. It was the largest libel award in the history of Alabama. So, what was the aftermath of this lawsuit? Another libel victory with another $500,000 in damages followed a few months later, this time in the suit brought by the mayor. With the looming threat of 3 more pending suits over the advertisement, their cumulative impact could have bankrupted the newspaper. The financial impact on Dr. King was equally pronounced. Fundraising for King through advertising had been crippled. Perhaps most seriously, the strategy of censorship by libel threats was working. Without press coverage, the impact of the movement would be thwarted. By the time the Alabama Supreme Court had affirmed the trial court ruling in 1962, the Times had kept its reporters away from Alabama and relied on wire services for more than a year. Journalists Janine Roberts and Hank Kibernoff stated, quote, public officials in 3 southern states had no fewer than 17 libel lawsuits pending against newspapers, magazines, and a television station, seeking total damages that exceeded $288 million. The court would decide nothing other than how free the press would be. If the decision went against the Times, would reporters be vulnerable to every libel claim filed by a ticked-off sheriff, unquote? So what happened next? A new Supreme Court case would come up called New York Times Company versus Sullivan. Let's go over this case. In the legal briefs leading up to the Supreme Court, the defendants took strikingly different approaches. The New York Times team, led by Columbia Law School professor Herbert Westchester, focused almost entirely on the free press and free speech issues involved. Criticism of government officials is essential to the First Amendment, and state libel laws should not be allowed to undermine that freedom. Westchesler's main argument was that, quote, the First Amendment was precisely designed to do away with punishment for criticism of the government and criticisms of officials, unquote. And therefore, the First Amendment must limit the ability of state libel laws to punish such criticism. If the Supreme Court did not impose free speech constraints on state libel law, massive damage awards like those in Sullivan would be, quote, a death penalty for any newspaper if multiplied, unquote. Representing the ministers was Samuel R. Pierce, Jr., where he said, quote, the sole purpose of this litigation is to suppress and punish expressions of support for the cause of racial equality and to try to keep those who are actively engaged in their fight for civil rights, such as the ministers in this case, from continuing to participate in that struggle, unquote. Nachman argued that the only way in which the defendants could succeed was if the Supreme Court granted newspapers, quote, absolute immunity from anything it publishes, unquote, and the result of such blanket protection, quote, would have a lasting devastating effect on this nation, unquote. He went so far as to say that even if a newspaper had a reasonable belief in the truth of what it published, it would still be subject to punishment under Alabama law if any statement turned out not to be fully accurate. Justice William J. Brennan's opinion for the Supreme Court outlined that sweeping change was to follow. He stated, quote, "We consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. Whether or not a newspaper can survive a succession of such judgments, the pall of fear and timidity imposed upon those who would give voice to public criticism is an atmosphere in which the First Amendment freedoms cannot survive. Under such a rule, would-be critics of official conduct may be deterred from voicing their criticism, even though it is believed to be true, and even though it is, in fact, true because of doubt whether it can be proved in court or fear of the expense of having to do so," unquote. Essentially, Brennan found that the defendants did not make any statements with reckless disregard of the truth, even if some of those statements in the advertisement were false and could have been checked more thoroughly. The decision went on to hold that the advertisement was also insufficiently of and concerning Sullivan in that, in quote, impersonal attack on governmental operations, unquote, cannot in and of itself constitute libel of an unnamed, quote, official responsible for those operations, unquote. For both of these reasons, the libel decision of the Alabama Supreme Court was reversed, and all of the defendants had now won a major case. So, in crafting the actual malice test, Brennan sought to strike a balance between blanket protection for all incorrect statements and no protection for any inaccuracies. Contrary to popular belief, the actual malice standard does not have anything to do with ill will or bad intent. What this meant, and continues to mean for journalists, is that they need not be infallible, but they cannot make stuff up, such as, quote, knowledge that it was false, unquote, and they also can't turn a blind eye to the truth or contradictory information, such as reckless disregard. This means a public figure is required to prove not just a statement is false, but also provided the speaker knew it was false or acted with reckless disregard for whether it was false. This standard protects reporting and commentary on public affairs by making it difficult to win libel cases against journalists and publishers. This case is considered essential for an informed citizenry and public discourse, as it allows the press to act as a watchdog on the government and powerful individuals. Without this protection, the fear of costly lawsuits could lead to self-censorship and discourage reporting on important issues, which would make it difficult to freely share information with each other. Now, what does the New York Times versus Sullivan case mean for us today? Let's look at a modern example of this. When Donald Trump was a presidential candidate in 2016, one of his campaign promises was his vow to, quote, open up our libel laws, unquote. At a 2016 Texas rally during the Republican primary, as he launched into a familiar attack on the media, it soon took an unexpected turn when he said, quote, "I'll tell you what, I think the media is among the most dishonest groups of people I've ever met. And believe me, if I become president, oh, do they have problems. They're going to have such problems. I'm going to open up our libel laws so when they write purposefully negative and horrible and false articles, we can sue them and win lots of money. So we're going to open up those libel laws, folks, and we're going to have people sue you like you never got sued before. We are going to take a strong look at our country's libel laws so that when somebody says something that is totally false and knowingly false, that the person who has been abused, defamed, libeled will have meaningful recourse," unquote. However, after analyzing and understanding the Sullivan decision, Trump's claims about libel law are inaccurate at best. Contrary to his repeated assertions, the press is not at all protected from making, quote, totally false and knowingly false unquote statements. If the media lies, the actual malice standard does not shield them from the repercussions of publishing what they know to be false, and they would undoubtedly lose a libel suit regarding any such public remarks. What the Supreme Court recognized in Sullivan was that the First Amendment itself limits the bounds of state libel law. Consequently, the free press protections that Trump objected to are constitutional in nature and cannot be changed by the president or even Congress. It is unclear whether Trump did not understand the actual malice test or is intentionally misrepresenting the state of the law to make the news media look like they are doing anything they want without standards. Whatever the reason, it seemed that Trump was following in the direct footsteps of another president, Richard Nixon, who also viewed the media as his enemy. The similarities between the Richard Nixon and Donald Trump's statements on libel are telling. When presidents feel particularly threatened by press scrutiny because they dislike being criticized, they lash out at First Amendment protections, which allow people to criticize public figures. Understanding the history of the Sullivan case enables Americans to better understand the motivations of a president and any public figure when they attack libel laws and the free press protections. For the majority of the time, those public figures express their disagreements with the person criticizing them and calling the public figures out for doing something wrong. So, you now know you can speak up and speak out against the government and institutions as long as your statements are true and are not purposefully spreading disinformation. In the next video, we will talk about the right to non-destructive protest in school. Until then, please like this video, subscribe to my YouTube channel, and turn on the post notifications so you will be notified when I post my next video. I appreciate your support. Remember, you are powerful, you are capable, and you are the changemaker our society needs. Thank you so much for watching this video. I will see you soon.